Well, the state brought evidence contradicting a previous witness, Mnisi's girlfriend, who testified they were together on the day of Fose's murder. But cell phone records brought before court suggest otherwise.
Yeah, I have the cell phone record. That was the record for the Vodacom cell phone number 079 716 1533, which the phone belongs to the applicant before court. Your Worship, the information that I read here is on page 10 of 24. That shows that on the 31st May 2025, time 16:55 and 49 seconds, the applicant before court, the tower shows Davidton. 31st May 2025, time is 17:14, just 14 minutes past 5. It shows here that it was at Davidton, whereby he had communication with another person named Fish here, when we analyze it. The other date is 31st May 2025, time 19:53. The tower, it shows Matulesville. And then
let's go to 20 hours, 1 minute, 47 seconds.
Yes, Your Worship, here it was on the 31st May 2025. The time is 20 hours, 1 minute and 47 seconds. The tower shows us Kagiso.
So the girlfriend who he called could not be called up to say the applicant remained with him from the time he came from the meeting up until the next morning. That's a lie, according to the tower location of his cell phone, correct?
That's correct, Your Worship.
Mnisi's lawyer argued that there was no evidence pointing to Mnisi being last seen with the child, as the only witness, Mnisi's ex-girlfriend, who said she did, was not cooperating with authorities. It also emerged that Mnisi had violated his parole conditions. But his lawyer said the two matters should be looked at differently.
The thing is, why at this stage do we still have him as a suspect?
Yes, that I cannot answer.
No, Yosip, I'm asking, hence I said it's just academic. Why are we still having the applicant as a suspect in this case when clearly there is no shred of evidence linking him to the commission of the offense? Yes, our law allows that he can be granted bail whilst the police are investigating the matter. That is acceptable. But Yoship, coming back to the issue of parole. When bail is granted, the court is also allowed to make conditions attached to his release on bail. Now, it would be simple for one to say, but if he breaks parole conditions, how will he take bail conditions seriously? But I still want to say that the conditions, if they are strict enough, if the bail conditions are strict enough, and at this point in time, I'm still repeating that it will appear that there is nothing that will make the accused not to comply with the bail conditions if granted.
Well, the presiding magistrate found it would be in the interest of justice to grant him bail.
The question arises if these conditions, seen in the light of subsection 8, or the breaking of the parole, is sufficient to finding that there is no prima facie case weighs heavily enough with the court to now deny bail on those because of those reasons only. The court finds that it would not be in the interest of justice to keep the applicant in custody only because he had broken his bail conditions. His parole conditions. As a matter of fact, his right enshrined in the Constitution of freedom of movement, in the sense thereof that he has the right of freedom to be released on bail, would be seriously infringed. And the court finds that the applicant has, on a balance of probability, shown that that exceptional circumstances do exist, why it would be in the interest of justice that he be released on bail.
As the NPA, we accept the court's decision. The court decided to grant Mduduzi Mnisi bail in the amount of 5,000 rands, and the matter will be back in court on Friday, the 11th of July, for further investigations.
Well, the family has also reacted to the outcome. He says he was hoping that he would be kept behind bars until investigations are complete. He says that they're hoping to find justice. Crisaldo Lewis, SABC News at the Roodepoort Magistrate's Court.